Thank you. We're now taking up S-163, an act relating to state court jurisdiction for special immigrant juvenile status. And we have with us Anarchy. I'm sorry, Director Radke. I have messed up more names in this week. It must be ready for a week off.
It's the spelling. It throws everybody off. It's Erica.
Well, I was trying, and it's not like we haven't met before. Well, anyway, the bill is 163, and it's really anytime we get into immigration status and so forth, we did think we should hear from the Department of Children and Families, which is often charged with taking care of these kids. So if you or Jennifer Micah, the counsel for the department, wish to speak on this, we'd appreciate any thoughts you have.
Great. I will just do a few words of introduction and then turn it over to Jennifer.
Fine.
So good morning, Chairman Sears and members of the committee. For the record, my name is Erica Radke, Deputy Commissioner of the Family Services Division of DCF. I'd like to thank you all for inviting us today to discuss Senate Bill 163. The DCF does have some questions or concerns about what the bill would require for the department in terms of guardianship for individuals over the age of 18 that would require this special immigrant status. And with that being said, I'll turn it over to DCF General Counsel Jennifer Micah, who will provide specific details outlining our position. Okay. Jennifer?
We can't hear you, Jennifer.
Oh, can you hear me now?
Yes, perfect.
Okay. Thank you for inviting me. I'm Jennifer Micah, DCF General Counsel. You've asked us to present testimony on S-163 relating to special immigrant status for juveniles, the purpose of which was explained to you by Rebecca Turner and Jill Rudge, namely to provide Vermont courts with the jurisdiction they need to provide youth with a venue to get a hearing that can lead to greater opportunities for citizenship offered already by the federal government. I understand that you passed the up to age 18 bill almost exactly 2 years ago, and I understand that it was slightly derailed by the lockdowns, which is why you didn't get up to age 21. Erin Jacobson has filled me in a little bit on that, and she might talk to you a little bit more. So the reason it didn't go up to age 21, I think, is just the confusion that arises as anytime you go past age 18 due to issues around adulthood. In the nearly 2 years that this bill has been on the books, and recognizing that these guardianships were in fact happening even before the legislation was passed, DCF has not had a youth placed in our custody for these purposes that I have been able to ascertain in reaching out to as many people at DCF as I could. I have spoken with Erin Jacobson and Rebecca Turner about this bill, and by and large, we don't have concerns about it, except for the fact that there is confusion about whether the over age 18 includes DCF custody when it talks about guardianship. And on page 5, section 5, the language states that a court is permitted to extend guardianship beyond a person's 18th birthday. It does not have any exemption for DCF, nor does it specifically state that DCF is included. We do maintain custody over people who are 18 or over for CHINS cases. We do not do it for anything else, but we do have extended care agreements with youth. Those are not custodial in that they do not arise from a court hearing or from a court order. Those are purely voluntary. This is something different that would require a court order for this guardianship, and we do not currently have capacity for that. So if that is something that is going to be asked of us, we would need to talk about what impact that might have the work that we already do. But like I said, I have been in touch with Rebecca and with Erin, and we have all agreed that we need to keep talking about it and are working together to see what we can do to come up with language that would be acceptable to all of us, because I think there is still some disagreement around that particular piece.
Okay.
Sorry, are you looking for questions?
Yeah, does that complete your testimony on
Yes, it does. Thank
the
you.
rest of the bill is okay?
Yes,
As far as
that's
DCF,
that's really the only issue we have is what does it mean for DCF's custody of over 18s?
Alice, did you have a comment or question?
I do have, I think, two questions. I just lost them when I turned to that page. Just a moment, please. The section I was asking about was on page 6 of 7, section F. It's talking about referral for services or protection, and an at-risk non-citizen who is the subject of a petition for special findings under this section may be referred for psychiatric, psychological, education, occupational, medical, dental, social services, etc. And what I'm wondering about is you may be somebody who's not even, the petition has not gone through, but a petition has been filed, would DCF be responsible for paying for all of these services? Who would be paying for these things? And would they be eligible for Medicaid?
So those are questions that I think Erin Jacobson would be better positioned to answer, because she has in fact done this work and she was involved in the drafting of the bill. So I think that she would be the one to answer those specific questions. I was curious about that when I listened to the testimony last week, though, about where do the kids go for these evaluations and who would pay for them.
Right. And also at the line 19 of the same page, it says that the section shall be liberally construed. So it seems like, that would be one thing. If you're looking at it liberally, it seems like, yes, DCF might be responsible. Who knows?
It could be another department.
There's no specific
Responsible.
language around the budgeting for that in here anywhere.
Right. And I'm also looking on page 4. There's a couple of places in section B, it uses the terms has suffered from abuse, neglect, abandonment, or similar circumstances. I mean, just kind of seems very loose, similar circumstances. And not that you have to answer that, but it's certain. And line 18 also, when it speaks about when considering an at-risk non-citizen child's health, safety, or welfare, the court shall consider whether present or past living conditions will adversely affect the child's physical, mental, or emotional health. What are they looking for? I'm not sure what's going on there.
I think that those are other questions, Erin.
Thanks.
Okay. Are there any questions for DCF? I think it's pretty clear. Your concern is the age 18 to 21. And currently that's only a voluntary situation for kids who have been abused or neglected. Is that correct?
That's correct. It's voluntary and outside of a court. There's no court involvement in that.
Unfortunately, yeah. I found out today at the last minute that Rebecca Wasserman's not available to us, and she's going to listen to this on YouTube. So I'm going to have to figure out how to answer some of Senator Nick's questions. But for the present, in terms of DCF, you have no questions about the rest of the bill. It's just that one fact.
We just really need clarification on whether the expectation is that DCF would be taking kids into custody who are over age 18 and what would be our responsibilities in that regard. And obviously we feel our system is already strained. And so it would be a heavy lift for us, even if there weren't that many, which it seems that there aren't, but it could also become a more widely used avenue if people did start realizing that it was available. And we don't currently have, for instance, something like extended foster care, which other states might have, and we would like to do that, but we need more funding and we would need more staff for that. And we are planning that, but that's in the future. So this would be an element of that, but we're not ready for it yet.
Okay.
And I would also add that some of the language that Senator Nitka pointed out too, where it was ambiguous in terms of neglect or treatment from the past, then those types of issues really would not fit into our statutory scheme either. So those youth would not really be able to be under our jurisdiction. So there does seem to be some ambiguity that would need to be addressed.
Okay.
And if I could just make one more clarification about the kids who are in extended care, those are kids that are already known to us. They come up through as when they're minors, and then they can stay in the system if they choose to. But this potentially would allow, a 19 or 20-year-old to be placed in our custody, which would be really very difficult for us not knowing anything.
My assumption is those voluntary arrangements are sometimes kids who were graduated from high school and you don't want to ship them off at 18, or even college students or whatever. And you're trying to, follow through with the child until they're able to be on their own.
Right. The extended care is actually for high school students, but it can go up to age 23. And then we have another program for other kids who are not in extended care, but for whom we will provide assistance, finding a home and employment and, all those adult things that you need to do when you don't have adults helping you.
Exactly, just to make that transition to adulthood as smooth as possible.
I remember one time having an agreement for a kid that was at 204 who was turning 18 in July and had a full scholarship to Vermont Tech, but they didn't open till September, and there was fear of what would happen if he was on his own for 2 months. The fear was well-founded, by the way, but he was not willing to provide a voluntary agreement, but I think DCF was willing to continue him until he got to Vermont Tech. The good news is he's doing very well now, and he's in his 40s.
That is good news.
Yeah, that's the good news. The bad news is he never got to Vermont Tech. But anyway, that's a little side story, but it's a similar problem. So I guess if Judge Zone doesn't mind, we're going to jump to Aaron Jacobson. And do you have similar concerns about the 18 to 21? And can you help with any of Senator Nitka's questions or concerns?
I can certainly try. Thank you. For the record, my name is Erin Jacobson. I am co-director of the Community Justice Division at the Attorney General's office, but I'm also still part-time until March 4th at Vermont Law School's Immigration Clinic. So I'm wearing 2 hats, and hopefully that's, the primary hat here is just to provide some historical information about how we got to this bill, should that be helpful, but then yes, also to answer any questions that relate specifically to immigration and the bill itself. The first question that relates to DCF's concerns regarding the intention of the bill to create an obligation for DCF to provide over 18 guardianships or an over 18 custody situation. That was not the intention of the bill. And in fact, in the drafting, that didn't even occur to us. It didn't occur to me. I can't actually speak for Attorney Wasserman, but the most common situation you would see, which this bill is intended to provide for, is a youth who is about to turn 18 and so age out of the system, such that there's no a court would not have jurisdiction over the care and custody determinations for that kid, whether that's a parentage or through a divorce or a guardianship in probate court. So to protect those kids who might continue to need some care, it was envisioned that there could be an extended guardianship just between like private parties, a kinship placement, for example, maybe a grandmother or a sister, an uncle. And then through that extended guardianship up to age 21, this bill would allow for the child to request the special findings from the probate court. So just giving the probate court both the jurisdiction to allow for this extended guardianship, or even maybe for a new guardianship for someone over 18, and to provide the requested special findings. That's really the only substantive expansion that we intended in terms of like a new program for kids over 18. Otherwise, the intent is really just to allow for courts to provide the special findings that are requested by the non-citizen child who meets the specific special order in order to then apply for immigration status with the federal agency. It wasn't the intention that it would somehow create a new obligation by DCF. That wasn't what we envisioned. So happy to keep working with Rebecca Wasserman and DCF on that, and Rebecca Turner as well. You're welcome. Senator Nicka's questions, those are really good ones. In terms of the referral to services, again, it wasn't envisioned that this was going to create some kind of obligation by programs to pay for these services. I will say that I think was it this past summer, Vermont just expanded Dr. Dinosaur coverage to all Vermont pregnant Vermonters and children, regardless of status. And if that did not go into effect in October, I think it might be this July. So to the extent that a child might be referred to a program that Medicaid could pay for, that non-citizen child should be eligible for that. Really, what those provisions are about, the referral for services, the provisions about thinking about a child's past situation, it's really to ensure that the court that is being asked to provide these special findings or the order is really thinking about the care and custody of the child, the needs of the child, the well-being of the child, because under federal immigration law, when the child then takes that order and goes to apply for special immigrant juvenile status, the immigration agency wants to be assured that the child was in state court, because not just because they need findings for a green card, but because the state court is the place where the judge sitting there has the expertise about care and custody of children. And that is in fact the underlying situation that is allowing the child to even be in the courthouse under the jurisdiction of the court. And so this bill is actually modeled on Maine's Special Immigrant Juvenile Findings Bill, which is the most recently passed bill by any state, and is passed at a time when the immigration agency was really cracking down on these special immigrant juvenile petitions. So what we attempted to do was to really make sure that it's clear in this bill that when the child is before a state court judge, it's really about the care and custody and well-being of the child. That's what the state court judges have jurisdiction over and expertise in. And so that's what some of these provisions are about, not to create some kind of obligation that would require funding to provide.
So just to make sure I'm understanding, if the state court creates a guardianship over the child and the child is about to turn 18, when the child turns 18, they would be able to obtain those services either under Medicaid or whatever. You know, it could be in a home with an uncle or an aunt or something of that nature. Is that the scenario we're really talking about? And then Vermont Medicaid might pay for some of the services that were outlined earlier in the bill that Senator Nick was asking about.
It might, and I'm not an expert on Medicaid coverage and how far that coverage extends past the age of 18. But in your hypothetical, Chair Sears, that kid who is about to turn 18, who's already in a guardianship, that's precisely what the example that this bill is trying to address. So this kid has no status, is about to turn 18, is in a guardianship, running out of time otherwise under current law to get the special finding she needs to then be able to get immigration status. This bill would allow for the guardian to extend the guardianship and would allow the probate court to issue the special findings should they be substantiated by the child who's asking for them. And then if the probate court knew of some services that could that the court could connect the child to, that would be fine. It
So
would
it's
just
not-
indicate that the court is really considering the care, custody, and well-being of the child.
So DCF's concerns could be addressed by making clear that they're not necessarily in DCF's custody.
Absolutely. I think it would just need some clarifying language that we could work with Attorney Wasserman on.
Unless there was a criminal case, they couldn't get, I don't think they can get into DCF's custody after age of 18. Under raise the age if there was a criminal case, but then that could affect their immigrant status, I would assume.
It might, and that's a good question for DCF. My understanding is that they don't have custody of kids over 18. They have these extended care agreements. But I'm not the expert about DCF custody over 18.
Or Erica.
Senator Sears,
Yes.
did you ask me a question in terms of the raise the age?
Yeah. If
You are correct that it would be under raise the age 18 and over. That would be a way for custody to sort of come into DCF. And I'm not sure the immigration laws either, but I imagine that would impact that status.
yeah, that might actually impact the person's status to remain.
That would be for the immigration attorney to fight with
Yeah.
DHS about. Yeah.
Okay. Any other questions for Aaron? Thank you so much for clearing some of that up. Does that help you, Senator Nika?
Well, I think there are some risky parts here for DCF. So I think that maybe Aaron and DCF can work these things out somehow to clarify some things.
Yeah. And if Betsy can help with that, perhaps during the town meeting week break, we can find some time to put together some language that helps with all of this. And we can come back to this after town meeting. But Judge Zone is our next witness on this subject. And Judge, welcome.
Thank you. Good morning. Tom Zone, Chief Superior Judge. The statute was originally enacted under Title 14, Section 3098, effective on October 7th of 2020. And the new statute adds a number of definitions and additional components to it. When I took a look at this, if you go to page 3, line 3, there was an addition. It says an at-risk non-citizen child against whom charges have been filed in the criminal division may file a petition for special immigration status in the court. The court is defined as the family division or probate division in connection with the definition section that's been added. My question on this provision that has been suggested is, why is it necessary? And I ask that because it seems to potentially sow some confusion to mentioning that if someone's in the criminal division, they can file it in the court. Well, is it the criminal court or is it the court that's actually defined in the statute? And the more fundamental question is, why is this section necessary? Because I have not identified anything that says someone who has criminal charges can't file for this anyway. And so I'm not sure that subsection 2 under jurisdiction is necessary, but if it's found that it is necessary or believe that it is, I would suggest getting rid of the last 3 words that say in the court. That way there's no confusion about which court, and it would clearly identify only the court of the definition, which is the family division and the probate division. The next part I want to talk about is still on page 3. Previously, the statute, as it's currently enacted, says that if an order is requested from the court. The new language on line 12 says, if an at-risk non-citizen child petitions the court, thereby vesting the ability to petition in the non-citizen immigrant child.
I'm sorry, what page are you on?
Page 3.
Oh, I'm sorry, I'm still
Line
on
12.
page 2. Okay,
Page 3, line
there I
12.
go. Okay, I've got.
So it now, the proposed language, it says if an at-risk non-citizen child petitions. And this raises the question of a child filing for his or her own order. We generally don't have that. It would be, for instance, if you're looking in the Title 14 for guardianships for minors, it says a parent or person interested in the welfare of a minor. If DCF has custody, it may be appropriate to say that or state agency having custody, something like that to add, so you don't have a situation where it appears that statutorily a child would be the one filing their own petition.
Yeah, I have a note here. It says it mirrors federal law. And that may be why, again, we don't have Betsy Wasserman here to help us with it, but that's probably where the language came from.
I would suggest if you can maybe move the words a little bit, then if a petition is filed on behalf of a non-citizen child, you can, something like that you might want to consider. But again, it should be clear who has the right to petition. Under our guardianship statutes for minors, it's clear. Under our relief from abuse statutes, it's clear that there has to be a parent or interested person for the minors, or a limited exception for individuals age 16 or older to file their own.
Mm-hmm.
The next section I want to touch on, we keep hearing about guardianship, and I agree. When you look on page 4, at the bottom of page 4, it talks about extension of guardianship in line 20. The intent of that, from what I understand from Ms. Micah, is for individuals who are minors who currently have a guardianship, and therefore that guardianship will be continued. Well, that makes sense, but I do question, if you look at the first sentence, it says, at the request or consent of the at-risk non-citizen child presently under guardianship, comma, or with the consent of the person under guardianship, comma, the court may extend an existing guardianship. I may be missing something, but I don't see the necessity for both of those clauses, because aren't we only dealing with the non-citizen child presently under guardianship who is actually the person under guardianship, which is the subject of the section. And if that's correct, I don't know that that second clause is necessary, because this should only be covering the non-citizen child, because that's all this statute is referring to. Does that make sense?
Makes sense, yeah.
So again, I leave open that I might be missing something, but it just seems to me that it's referring to the same person, i.e. the ward under the guardianship that is already in existence for the minor. And I assume that that would be a minor guardianship that has been entered under Title 14. Which gets us to then section 5 on page 5, requesting an initial guardianship. What I understand this section to seek is that it wants to make it clear that for individuals who are 18 to 21, they're not deprived of seeking this status for purposes of going to court and getting the requisite order for use in federal proceedings. It mentions the consent, which makes sense, obviously, because this person is now an adult for purposes of making their own decisions, but the court may appoint a guardian to assist them. What does not appear clear is the procedure for that to occur. In other words, while this statute says that a certain category of individuals is now eligible for a guardianship, I cannot identify a statutory framework that this simply fits in and you then follow the procedures. In other words, it's not a guardianship for a minor, because that under Title 14, Section 2623 identifies people who are eligible for minor guardianships as being under 18. And it would not seem to fit clearly within other provisions for individuals who may need guardianships. And so my question is, where does this fit into the guardianship scheme when a court gets this request, a petition saying, well, we're filing under this section for a guardianship? Where do we on the court plug it in to the statutes that exist for establishment of guardianships? And it doesn't seem to answer that question. And so I think it could lead to some confusion, because again, there's no clear fit for guardianships. And I don't know if Ms. Micah or others have considered that, but it seems as though it's creating a guardianship without the rules and statutes that tell us where it fits in. But
Okay.
so those were my comments. I do know that our probate and family oversight committees, I believe it was oversight committees, have indicated they were talking about getting together to potentially consider a committee to look at this type of issue for coming up with proposals and rules. But as of this time, I don't believe that had occurred.
Okay. Okay, thank you, Judge. And any questions for Judge Zone? All right, thank you. Well, we've got a lot of work to do on this bill, appears. And hopefully folks can get together and come up with some ideas or solutions. I'd very much like to see this bill passed. I think it's important. Anyhow, let's see where we can come up the week after town meeting. Looks like we're going to be busy that week, as we always are. That crossover. All right. Now, we have a vote on a revote on 3 judges. So the first judge is Judge Heather Gray. And there's a motion to report favorably the confirmation of Judge Gray. Senator Nitka?
Make a motion that we report favorably the appointment of Judge Heather Gray to the Superior Court bench for a term of 6 years.
Okay, thank you. Just for the record, the reason that we're doing this vote, we've already voted on these judges, but unfortunately the nomination papers didn't get from the governor to the Senate secretary. And we were unaware that did not have the nominations, and we've already talked to them, and so we've already voted on them. But according to the Senate secretary, we have to have a revote before we can report. So, is there any? Yes.
I may have, not sure, I should, maybe Judge Stoney knows the answer to this. I should not have included the part for a term of 6 years because perhaps she's filling out the term
Yeah.
of another person. So
Yeah, I think we're just going to nominate them until the next time until they're up for judicial retention.
3/31/27.
Okay. Any further discussion? Thank you, Senator Nitka. Peggy, would you please call the roll?
we need,
Senator Benning,
Yes.
Senator Nika,
yes,
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears,
Yes. Okay, that's unanimous. I believe Senator Nitka, you're reporting.
yes.
The next one is Judge Justin Juron, Superior Court Judge from, I believe, Chittenden County. Is there a motion to report favorably? Senator Baruth has moved that we report favorably the name for confirmation, Judge Justin Juron. Is there any discussion? Hearing none. Peggy, could you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes,
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears,
Yes. The next is Judge Elizabeth
Novotny.
Novotny. My God, she's her history with this committee is she and Judge Kalfas were actually the head of the Department of Public Safety divisions that were always testifying in this committee, and then she became a lobbyist for many organizations, and so we know her well. And then I flipped the name early. So, is there any further discussion? Hearing none. Peggy, would you please call the roll?
Senator Benning,
Yes.
Senator Nika,
yes,
Senator White,
Oh, yes, yes.
Senator Baruth,
Yes.
Senator Sears,
Yes. All right. Who was reporting, Judge Novotny?
I was, and I'm going to have to get the stuff sent to me again because I have no idea where, after all this time, where it is.
Can you take
For
care of that,
information?
Judge? Peggy, yeah. Can you take care of that, please?
Yep. and
Or
who-
Judge Zone? Huh?
Yeah, I was gonna say, I had the same problem with Judge Kalfas. I don't know what I did with my materials.
Yeah, I have no idea.
I'll get it
I'm
to
sure
you.
Alice is not so disorganized.
I'm sure she is ready and able.
I do have it, but you wouldn't believe it if you saw the place I'm working in.
Who's the reporter for Judge Jiron?
I am.
Senator Baruth.
Okay,
Senator White is Judge Novotny, and Senator Nitka is Judge Gray.
got it.
Senator
these
Benning
likely-
is Judge Kalfas.
Are these likely to come up on Friday?
That's what I was wondering.
I
That
don't
soon?
know. I don't think so, because I think they have to be on the notice calendar for a week
Oh, yeah, that's right,
Yeah.
for, I think, 5 days. Yeah.
or 5 days.
Yeah.
All right.
Good. Since next week is town meeting week, I'll probably lose my materials again before we get there.
You can just go from memory on Judge Kalfas, Joe.
Yep.
We just might want to say on the record that we didn't revote on Judge Kalfas because we actually received the material from the governor's office in June on that one, but not the others. So
Thank you, Judge Nick. I'm having a rough time
I like
today. I
Judge
just
Nitka.
elevated
That
you
sounds
to
good.
judge.
So,
All in
can-
favor of
can-
making Senator Nitka Judge Nitka? Okay.
I'd even go for
unanimous.
Justice Nitka.
oh,
Well,
Oh.
she is a justice of the peace, I'm sure.
So can I ask what day we heard from these people? Because it might be helpful. I might go back and look at the testimony that they gave us.
Yeah,
I can-
Peggy sent us memos on them the day that we met with them, and that was,
I'll send it to you.
they were
Okay.
all Fridays in January, I believe.
Okay, if you can send me the date that we did Beth Novotny, that
Or
would
it
be
might
great.
have been on,
Will
might
do.
have been one in February.
Thank you,
all right.
Peggy.
The next bill up for retention, up for discussion is S-268, the Right to Farm Bill. And Mike O'Grady is here. And we have a number of other people in the room who are interested in the bill. I was kind of struck by the testimony. The farmers that testified were very well-spoken, and I think fully understood their concern, but the concern seemed to be nuisance suits. And the testimony one, there's only been 2 in the last 40 years. And I don't know, I don't want to get into the details of a suit that's ongoing here. So I'm wondering if this bill is really needed. Senator White.
So I think that one of the things that we heard, and I'm not sure that this bill would solve that, Michael might know, but was that it might not rise to the level of a nuisance suit, but there's a lot of, I don't know if you want to say harassment, but I was taken by the testimony of the person that moved in and buys his produce from the neighboring farm and then blocked the driveway so they couldn't spread the chicken manure. So but I'm not sure that this bill addresses that, would solve that anyway, those kind of harassment. Well, you know what my solution was, but I won't say it on YouTube, but I think that issue of people moving from out of the area and don't understand what farming is all about and think they're moving to quaint, cute little Vermont that has little white church spires, and then they find out that it smells like pigs and chickens. So I don't know that this would solve that.
Yeah, and one of the things that I heard discussed was the concern about many of those people who moved to Vermont and have not even personally seen, but just seen videos of their new property that they've just purchased. And that was one of the concerns I heard from the farmers. Senator Bruce?
Yeah, I feel as though the current state of affairs where the farmer has a rebuttable presumption is already quite a bit of protection. I was in this bill put off by the statutory declaration of the farmer's right to do this long list of things, which seems to me like going from a state of affairs where the farmer has the rebuttable presumption, but someone could still get relief if they could rebut that presumption, to a state of affairs where people would be denied this civil remedy because we had laid out a series of statutory shields for farmers. And we're in a time where especially water quality is, the source of legitimate litigation, because we're trying to protect the health of the state. So that's one example of why I would be uncomfortable forwarding this bill. I don't think it's needed, but I think the advocates for it were passionate, as you might expect.
Yeah, I think we all agree that they were passionate, that they have some points. I thought the one thing, how do we deal with the nuisance issues Mike, under current law?
The current right to farm is a nuisance protection statute. As Senator Baruth referred to, there is a rebuttable presumption that they are not a nuisance if they are complying with the conditions. They're in compliance with the law. They are following the RAPs. And what's the third? Oh, hold on a second. It was established prior to surrounding non-agricultural activities, and it has not significantly changed since the commencement of the prior surrounding non-agricultural activity. So that's the presumption. They're not a nuisance if they meet those conditions. However, Senator Baruth referred to a person who is claiming nuisance can rebut the presumption by showing that the activity has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with the use and enjoyment of the neighboring property. So current law is only nuisance protection. The proposed law would only be nuisance protection. Other states do extend the right to farm protection to trespass. A handful of states do that, and 1 or 2 states extend it to negligence. That is not the case in 268. A person could still bring a trespass claim, as a couple of the witnesses in the last hearing noted, could still bring a negligence claim. Water quality claims are not affected by the current law or by S268. Those are governed by the Federal Clean Water Act and the state's Clean Water Act provisions. There's something called a citizen supervision under the Clean Water Act, and a person can bring a claim against their neighbor, and ANR has the ability to step into that or not, and EPA has the same option. There was testimony that regardless of S268, that farmers would wind up in federal court because of outfalls from water and subsurface tile drainage. Vermont's a delegated state under the Clean Water Act. Vermont's the one that enforces the Clean Water Act and NIPTE's permits in the state. I think the state would act first before US EPA got involved. So I don't see, it's possible, but I don't see many of these cases going to federal court. I expect most of them would be in state court. But the witness is correct. There is case law around the country that subsurface tile drainage that drains into a water of the United States is a Clean Water Act issue. Current law covers subsurface tile drainage. 268 covers subsurface tile drainage. It doesn't remove the Clean Water Act's authority over them. It just says that they wouldn't be a nuisance if the conditions of current law or the conditions of 268 are met. So you're right. It only covers nuisance. It doesn't cover trespass, doesn't cover negligence, it doesn't cover water quality. It is more extensive than the current law, 268, but it is based on other state right to farms.
Well, Senator White.
So remind me what this does that, I mean, it gives a list, but remind me what this does that the current right to farm law doesn't do. What does it, I mean, the things that are on that list, wouldn't they also be protected under the current law if they met those 3 conditions? So what does this law do?
Some of them would be protected under current law, but some of them are not. And so it does expand the list of activities or the type of activities that would receive coverage, nuisance protection from suit. In addition, it eliminates the rebuttable presumption and just provides that if the conditions are met, then the farmer receives nuisance protection. That's
Wow.
probably the most significant portion of the bill, the removing that ability to overcome the nuisance protection through that rebutting of the presumption.
Thank you.
Thank you. Nobody brought it up, but is cannabis cultivation an agricultural?
Not yet.
Well, there is the miscellaneous bill over in,
Mhm.
or not miscellaneous, but the small plot bill in the Senate Agriculture Committee.
Mhm.
It's actually in Senate Finance. I'm going there this afternoon. The conversation was had in Senate Agriculture, and there was originally a desire to designate small cultivators as farming. Well, let me step back. Currently, under the bill you passed 2 years ago, cultivation of cannabis is not farming, except that certain small cultivators who already had land enrolled in use value can continue to enroll that land in use value if they start small cultivation outdoors on that land. There was desire by interested parties to treat, well, there's desire by interested parties to treat all cannabis cultivation as farming, but the board came forward with a request just to treat small cultivators as farming. The committee was going to go forward with that proposal, but then asked the Agency of Agriculture if they had any issues legally with designating cannabis cultivation as farming that was subject to their control. And they do, because the Agency of Agriculture does a lot of work and receives a lot of funding from the U.S. Department of Agriculture. And the U.S. Department of Agriculture almost always has provisions in their grant agreements and in their cooperative agreements that the grantee or the person that they're entering the cooperative agreement with maintains a drug-free workplace. And so there was concern by the Agency of Agriculture that they could lose funding, lose things like the Equal to Status program for slaughter, lose eligibility for NRCS equipped grants, etc. So the agency did not want to be the one regulating farming of cannabis. So what the committee did is it gave small cultivators the benefits of farming, but said that the control board is going to be the one to implement and administer those. And what they received, the benefits they received, they're going to be exempt from Act 250, as farming is exempt from Act 250. They're going to be exempt from municipal bylaws, as required agricultural practices are exempt from municipal bylaws. They maintain that same ability to enroll in use value that you gave to them 2 years ago. And then they will receive 3 sales tax exemptions for agricultural twine, like all the kind of minor agricultural materials, agricultural machinery, and then compost, manure, fertilizer. So that's what happened in S188. They're not farming, but they get the benefits of farming.
But in this, for the purposes of S268, that wouldn't be part of the.
They would not be an agricultural product.
If a neighbor claimed that the odor from the cannabis was noxious and troubled by it or something.
Right. If the cannabis that's being grown is hemp, then yes, that is an agricultural product. If the cannabis being grown is recreational cannabis, then no, that is not an agricultural product. And that will all be determined by the registration / license that the cultivator has. If you got a hemp registration, that's farming. If you got a cannabis license, that's not.
Okay, let me give a couple of seconds or minutes to anybody else who's listening in who would want to comment. I know John Groveman is here if he wanted to comment on any of the parts of the bill. And Jackie Folsom is also here representing the Vermont Farm Bureau.
Yeah, thank you, Sam. I appreciate the opportunity to just some brief comments, if that's okay with the committee.
Yeah, yeah.
So my testimony strongly agrees with what Senator Baruth was saying, just overall that the current, and what you said, Senator Sears, is that we haven't had very many nuisance suits since the law has been in effect, and this current system is fair in terms of the rebuttable presumption. It strikes that balance that my colleague from CLF spoke to when he testified, and so we don't really see that there's a problem. I think I understand the Addison County lawsuit that I think really prompted this. Has prompted the farmers that have some legitimate issues in terms of neighbors. But I think, as Senator White said, I don't think this bill would solve that problem, to try to seek a tightening of this right to farm law. And we think that the balance has worked well. There haven't been these lawsuits. And ironically, I want to emphasize a point I tried to make when I testified. We don't know what's going to happen in that Addison County case. The Addison County case may not find that that there was a nuisance. And as Attorney O'Grady said, in every one of these cases, there are three general across the country. There are three general legal theories that are raised. One is nuisance, others trespass, which Attorney O'Grady referenced, and then there's negligence. And all of those issues were raised in the Vorsterville case, and so we don't know what the judge is going to do. Because of the rebuttable presumption, the judge may well, find that nuisance is not available because it's a higher legal standard already to rebut the presumption. But I think it's important to have that in the range of legal remedies that people who are harmed can attempt to seek. And one area where I don't fully agree with Attorney O'Grady is I think water quality is an issue here. I agree that the Clean Water Act does provide the citizen suit provisions that Mike referenced. It's those provisions that I think Jerry Tarrant for the Vermont Bar was referencing, that people will go to use those remedies more. That was Jerry's testimony, because if you can't raise nuisance as an issue, you may turn more to the Clean Water Act remedies, and that does not only put you potentially in federal court, but also you could recover attorney's fees as well if you prevail. That's how that citizen suit provision works under the Clean Water Act. But in my experience, people seek the nuisance provisions because the federal clean water scheme is difficult to navigate, in large part for farming pollution, because of all the way the laws are written. Right now, we have basically this construct where if you're complying with the farm water regulations, the required agricultural practices, you're basically presumed by EPA and ANR and the Agency of Agriculture to be not polluting. And so if you're going to take a Clean Water Act water suit, you have to deal with that legal construct that's set up, which is difficult. For years, VNRC, in our struggles to clean up waters and to deal with water pollution, has said that those agricultural water quality practices are not strong enough, even though they were strengthened in 2015 when Act 64 was passed by the legislature. We're still seeing water pollution issues, and you could have a situation without the rebuttable presumption where if those practices are being complied with, you'd be shielded from raising nuisance in federal court if you brought a water issue. That Addison County case did raise water issues, and the issues were raised under nuisance, trespass, and negligence. And we think that in situations where if people move to the nuisance under the current law, then you can't raise those issues. And we're not saying that that should be changed, but under S268, even if you didn't move to the nuisance, if the nuisance moved to you, you would still be barred from raising a range of issues under nuisance, including water quality. And then we do have, I didn't get into this in the testimony because, I was trying to stay at a 30,000 foot level, but the long list of items that Senator White listed is very concerning in terms of what you couldn't raise, or what landowners would be precluded from addressing. Is a very expanded list over the existing law. So I hope that makes sense. These water quality issues are difficult, and the legal scheme is complicated, as all of the legal schemes that you hear about are. So I just wanted to make that point, and just because from our view, we think water is part of this.
Yeah. Thank you.
Thank you.
Jackie, any comments on the bill that you'd like to make?
Sure. Good morning. Thank you for letting me back in. I don't know, Senator Sears, were we going to keep this up again, or?
I'm not going to meet with you. I'm not meeting with you next week.
Okay, that sounds fair. Thank you. Well, yes, and thank you for your comments about the farmers who testified. I just want to say, as someone who's been speaking for agriculture for a long, long time, and not necessarily in front of this committee, it was really hard for them even to Zoom in to talk with you. They don't like being out in public. They don't like talking about what they're doing on their farms. And it's not because they're hiding anything. It's just because they don't think that they're well-spoken, even though I always tell them when they testify to speak from the heart, because that's the best way to do it. And I think that's what you were referencing when you were talking about their passion. I think that S268 it is in response to two things. For one, right to farm hasn't been updated in 20 years. So, after you've got a law that's been working for 20 years, it probably is time to revisit it, to double check and have both sides of the proponents and the opponents, or the supporters and the folks that are having concerns, check in and just update each other on how they think it's working. I also, surprisingly, Mr. Groveman, I will agree with you, and also with Senator Baruth, the fact that whenever you start putting lists in something, inevitably something's going to be left out. And my concern when I looked at that list, I did have a concern with the ditches and tile drainage, because it's still an issue that we're dealing with in Senate Agriculture, and we've had continuing discussions about that. So I was concerned to see that, but my biggest issue is, as I said, when you start a list, you're going to leave something out. And so we don't want to have to come back and say, oh, we forgot number 17 or something next year. This right to farm bill has got to be done right. It's got to be, it's got to work for the farmers. It's got to work for the neighbors. I think what I heard a lot in the testimony, and I think you all did too, was the concern of people moving in. It is well known that folks are running from a lot of things, and they're moving into Vermont. And this bill, I think one of the things we didn't quite get across on Friday was that this isn't just about dairy. This is about every type of agriculture that's in Vermont. I thought Lisa McDougall from the Fruit and Vegetable Growers was very eloquent in what she said regarding the fact that there are a lot of people that are coming up here, and we're not looking at 5,000 acre dairy farms. We're looking at 10, 20 acre small farms where people are learning how to farm. People may not understand how to farm. A lot of the resources for agriculture through UVM Extension and others have just been decimated by lack of personnel being replaced. So there are not a lot of resources sometimes for some of these folks that are moving in, or for the farmers who are moving and diversifying into something different. So it is a challenge, and I think that this rendition of attempting to strengthen the right to farm bill is partially a result of, it's been 20 years, it's partially a result of the farmers over in Addison County watching the trial going on And I think it's also a result of the fact that that agriculture in this state is changing drastically. It's becoming more efficient in many ways, but in many other ways, we have new people coming in, and that's wonderful. It's changing the face of Vermont agriculture, but we need to make sure as we go forward that whatever happens for the right to farm bill, and Vermont Farm Bureau is all for strengthening the language if it's necessary, and we will depend on you all to determine that. But I think you heard the concern from the farmers and the advocates on Friday that they are worried about where this is going in the future, and they just wanted to make sure that folks were paying attention and listening, and they wanted to make sure that if S268 goes through, this is something that they feel may help. And if you so determine that that isn't the case, then we will probably come back next year and try to find a better compromise that will suit everybody. And it may be predicated on the voice develop trial, and we'll just have to wait and see. So thank you very much for the opportunity to speak with you.
Senator White, did you have a question for Jackie?
Jackie, if you could, and thank you, if you could talk just a little bit about it seems a pretty dramatic move to remove and I think I have the words right here, rebuttable presumption. And the other thing is how this would help. There aren't a lot of nuisance suits, but there are a lot of harassments and that kind of thing. We heard that clearly. And how this would help that. How would this have helped the person whose neighbor blocked the driveway so they couldn't spread the chicken manure?
Yeah, Senator White, I wish I could help you on that, but I would really defer to Mr. O'Grady on that. I really don't have any background in law at all, so I'm unable to answer whether that would have helped. I do know on our own, when we were dairy farming, and we've been retired from dairying for 10 years, we're right on Route 2 in Cabot, and so we had animals out in pasture. We had a nice complex milking barn down there, and we would have people stop out of staters from all the time and walk into our pasture, try to pet the cows when we have cows out, and they don't know if it's a bull or not. We never had a bull. I would never do that. Anybody worth their salt would never go into a pasture not knowing what's in there. We actually had people in the summertime where we had the cows out, and they were calving. Some of us are used to seeing legs sticking out the back of a cow. It's a good thing. And we were watching and we were monitoring and we were letting this animal do her thing. But we would actually have tourists get out of their cars, go duck under the electric fence, go into the pasture, I don't know what they thought they were doing, to the point that we'd go running out there and say, what do you think you're doing? And they would say, well, you're not paying attention. You have no idea what's going on out there. There's a cow in pain. That harassment, I guess you could call it harassment, has been going on a long time. Farmers spend a lot of time educating people. And in fact, one of the policies we have in Farm Bureau, and you might chuckle at this, but it's something that we're worried about, is there is a policy that we have that says anybody that buys a farm has to be told by the realtor of the noise, the odor, the hours of operation, just to educate them, because we really understand that people are moving in and are not educated. But long story short, the rebuttable presumption, I don't know, and I would defer to Mr. O'Grady to have him talk to you about that.
So
Sorry.
Jackie, that's okay. So maybe we should, when people buy a farm, they're given some instructions. Maybe when somebody buys a house here or registers to vote, they should have to read and take a farm exam.
I would love that. I don't know if it's doable, but
probably not. But
no, and it's something that farmers need to be more proactive about. I know a lot of the people that you heard from on Friday, as you heard, they work with their neighbors. They try to tell them, if you're having a party, okay, I won't spread manure. Oh, if you're going to do this, okay, we'll do something else. the farmers understand the challenges. I think it's on the flip side, it's the neighbors and particularly some of the folks that are moving in. Although that's not necessarily true. It could be anybody that, as in this bill, if there's a change of farming operation, the dairy farm goes from having dairy to raising pigs, that's a different way of farming, and we need to be more proactive about it.
Thank you.
Thank
Thank
you.
you. Any other questions for Jackie? Mike, do you want to take this on, Senator White's questions about rebuttable presumptions? And
Well, first to the question of what would the existing right to farm law do or S268 do about the neighbor who blocked the driveway to prevent? It wouldn't do anything. Either the existing, because what the law is a protection from nuisance suits. And it doesn't prevent a person from filing a nuisance suit, and it doesn't prevent your neighbor from being a jerk. It is when a nuisance suit is filed, the court will review the conditions to see if you are presumed not to be a nuisance. So the complaints and comments, harassment, this does not prevent that. It does give a farmer some surety, both the existing law and 268, that if they are subject to a nuisance suit, that their practices that are compliant with the law, that they were engaged in, and that have not significantly changed, are protected and are not going to be found to be something that creates a nuisance for their neighbors. That's what the right to farm law in Vermont does, and the 268 would strengthen that protection, strengthen that surety for farmers. It does not go nearly as far as other states would or do. Oregon is my kind of case model for that, where it's not a nuisance unless you somehow damage a raw agricultural commodity or you cause a serious injury or death to someone. So that is kind of the high watermark and right to farm protection. That is not what 268 does. That's not what the current right to farm law does. So I'm not sure if I answered the question or just was talking to myself.
Oh, you did answer the question. You may have been talking to yourself, but you did help me. And I wonder if you could also comment on Jackie's concern about creating a list and having a list.
I mean, that's a valid concern for any list. But there's already a list in the right to farm law. There's already a significant list of what is an agricultural activity. That list doesn't necessarily reflect all of the activity that goes on farms. And the intent was to more accurately reflect what is actually farming, and extend the protection to those activities that are actually farming. Though her input about a list is all, there's something always omitted. It's likely the case, but the intent was to reflect what is actually farming, and all of those activities.
yeah, well, maybe Mike, that's helpful. My main questions have to do with the water quality and those issues. I mean, we all have been by farms where the odor is noxious, and or the farm vehicle going by your house, and when they're cutting the land next to mine, I have to close my windows, but that's part of the fact that they have, those things are annoying, but they're not to a level where I'm really concerned about. But living in an area of contamination, I've become more concerned about water quality than ever in my life. And I'm concerned about this bill from that water quality standpoint. Where a farmer has certain rules, I know, but we also know that those systems fail sometimes.
Right. And I won't say that a water quality issue or an agricultural practice that is under one of the ag water quality chapters would never cause a nuisance. It likely, it's possible. For example, the ban on spreading manure during the winter or on snow, that is actually a water quality requirement. That could create a nuisance if someone violated that. But they wouldn't get the protection of the right to farm law because they wouldn't satisfy the criteria of being in compliance with the law.
But I've had a number of complaints about that very issue in the springtime, and the farm is actually located on the state line. And according to some of my constituents who travel by there, they're violating that law. And the water is impacted by it. So I'm not sure the Department of Agriculture actually is the right one to say whether the rules are being followed or not.
The RAPs actually prohibit the discharge of agricultural waste to waters of the state. But there's a provision in both the Federal Clean Water Act and state law that if you are applying that manure, that agricultural waste, according to site-specific agronomic conditions, which is shorthand for a nutrient management plan. If you are applying according to a nutrient management plan, then that is not a discharge to waters, even if it runs off into the water. If you are applying according to your plan, that's not a discharge. It's called the Agricultural Stormwater Exemption, and that's under the Federal Clean Water Act. But if you are not following in your nutrient management plan, if your honey wagon breaks and there's runoff into the waters, which has happened, if you are directly discharging into a water through a hose or a ditch or conveyance into a water, which has happened, that is a direct discharge, and that is subject to enforcement by ANR and ultimately by US EPA if ANR doesn't effectively enforce. That authority is not affected by the current right to farm law or S-268. That is separate enforcement authority under a separate regulatory program with federal requirements that dictate what must be done. So that does, I still don't quite, I don't quite agree with the assertion that 268 will drive people to citizen suits that will wind up in court, because there's a provision in the citizen suit language that says before the person can initiate the citizen suit, they have to give the regulatory agency notice that they are going to initiate the citizen suit, and then the regulatory agency can respond, and if they're diligently enforcing, the citizen suit can't go forward. So I expect if there were citizen suit notices filed, ANR is going to enforce, and the citizen suit would not wind up in court. It would wind up in an enforcement action with ANR, which could ultimately go to court, but it would be an ANR enforcement action, not a citizen suit.
I think the CLA had some comments on the water, and Scott Sanderson is here if you'd like to make a brief comment about that.
Sure, absolutely. Thank you everyone for giving me the opportunity to testify again. Just for the record, my name is Scott Sanderson. I'm representing CLF. Yeah, on the water quality issues, I think I agree with most of what Attorney O'Grady has said in terms of, these, the current right to farm law and the right to farm bill, both not affecting the, litigation under the Clean Water Act. However, I think that it is the case that nuisance suits do that water quality issues can be encompassed in a nuisance lawsuit, although it may not be the most common form of nuisance lawsuit. It may not be the most common way of for a neighbor to deal with a water quality issue. Something like trespass or negligence might be a more common claim. All the same, I do think a nuisance is a way that a neighbor might frame a claim around water quality. I think beyond that, even more than the water quality issue, we've heard a lot about the rebuttable presumption, and that is really, for CLF, the primary concern here is that it seems like we've already got a very effective right to farm law on the books. And, it does a good job of balancing a farmer's interest in being protected from these unfair lawsuits that come as a result of misunderstanding when folks move in and are unfamiliar with farming. But at the same time, it makes it possible for neighbors to basically to protect themselves and their property when health, welfare, safety are on the line. Especially when an agency, for whatever reason, even if it doesn't have bandwidth or anything like that, isn't able to deal with that issue on behalf of that neighboring landowner. So yeah, I think upsetting that balance and upsetting a law that seems to be doing its job, is a major concern for us.
Thank you. John Groveman, do you have any further comments on the water issue?
Yeah, if I could just say one more
Water
thing.
quality, I should say.
Yeah, thank you very much, Senator. So I what Mike O'Grady laid out, I think in theory is how things should work. But the fact is, and this is something that we've been involved in advocacy for years and years at VNRC, enforcement is not happening in the way that it should. We've done a record request. We've looked into this. And there are often disputes between ANR and the Agency of Agriculture about whether a discharge exists. And we have seen situations, and you could have ANR in, and they would testify, and I think they would tell you straight up that there are disagreements between the two agencies about whether there is a violation and whether there is a discharge. And so it's just not so cut and dry about you're in compliance, you're not in compliance. We have a situation now where we have two agencies, the agency who's in charge of protecting our waters and the agency that's in charge of agriculture, not, often, I think I could say often, not agreeing on whether the rules are being followed and whether or not there's a discharge that should be enforced that violates state or federal water law. Jeff Wenberg, Governor Douglas's DC commissioner, testified just last week. He's on the Lake Champlain Citizens Advisory Committee, that we need to change the way we do enforcement around farm water pollution because the system's not working. He talked about how, just what I said, that there's often disagreements between the agencies, complaints are not addressed, issues are not addressed in a timely way or at all. And sometimes the courts are the safety valve where people go because you have this regulatory scheme, a very unusual one, where you have two agencies both regulating the same thing. As you all know, as legislators, that's not usually how we set it up. That's how we set it up in terms of water quality and farming. So it's just not that cut and dry. And we fear that there's a situation where if S268 moved forward, that there would be more of a shield for farmers to say we're in compliance, even though ANR might not agree with that. There was a dispute about it, but the Agency of Agriculture can deem a farm in compliance, and it could create a shield when there actually is a water quality issue that's not being addressed. So as my colleague at CLF said, the law seems to be working now. It's a powerful rebuttable presumption. People moving to the nuisance have a difficult time appropriately of raising these issues. But before this Addison County suit is resolved, to make these sort of changes, which could have consequences for how we deal with water and other issues, we just don't think it makes sense. And I heard, I would agree with Jackie Folsom. I think, the part where she said, why don't we see what happens with this case? And if they want to come back next year and there was something that the judge did in this case that upsets how the right to farm law works, then we'd be in a better position to judge that there's a problem that needs to be solved. So thank you.
Thank you.
For the opportunity.
Any further comments on this bill before we break for the day? I'll just leave you with, my concern about water quality and I think John put it well, that the issues between the Agency of Agriculture and the Agency of Natural Resources in terms of enforcement is a concern that probably ought to get addressed either by the administration or the legislature, but that does come into play. I've actually had situations down here with it, but I've also had situations where new guy moves into a neighborhood and decides that he wants to change the neighborhood back to what he had in New York or wherever, Boston, wherever. And
Whoop.
Is it me again, or is it
No,
Sears
Dick
this time?
froze. Yeah.
I
I
got
froze.
kicked out a little while ago.
Yeah.
well, I think when I'm frozen, it's time to leave. No, can you hear me now?
Yeah.
All right. I was talking about, what I've seen happen here when a new person moves in. I'm thinking particularly on the west end of Bennington, where there is a farm in the high-end neighborhood that one of our senators lives in. And there's a farm that's been there for centuries called Fairdale. It was originally Fairdale Farms. And they were quite a producer of products and so forth. And people who move in there sometimes have complaints about the noise and the odor, and they should have known that's what they're coming into. And I can understand the farmers' plight of getting those complaints. On the other hand, if they're doing something that, in terms of water quality, and there's disagreement between the two agencies, and this bill leaves it to the Agency of Agriculture to decide what is in compliance, that's troubling. As I read the bill, maybe I'm not understanding it completely, but maybe next time we come to this bill, Michael, you can explain to me how what I'm reading in the bill is that the right to farm is expanded to if they're compliant with the Agency of Agriculture. And we just heard there's disagreements between the two agencies in many cases.
You're correct. There is a provision in the bill that provides that the nuisance protection would extend if the farm was compliant with the RAPs, but it's only for nuisance protection. It's not about enforcement of the water quality laws. The inability of the two agencies to cooperate fully is a fact. The committees on agriculture have been trying to mitigate that over the years, and they continue to try to do that, but it's a fact.
Okay. Well, I think that's a great